Hello everyone, I am Vaishnavi Parate. I am a human rights activist at All India Human Rights Association, and today we are going to discuss and learn about types of writs given under Article 32 of Indian Constitution. So let's start. Let's start with the introduction. Article 32 confers the power to issue writs upon the Supreme Court, ensuring the protection and enforcement of fundamental rights. Article 32 of the Indian Constitution bestows upon individuals the fundamental right to approach the Supreme Court of India directly for the enforcement of their fundamental rights. These provisions, regarded as a cornerstone of the Constitution, empower citizens to seek legal remedies when their fundamental rights are violated, thus ensuring the protection and preservation of individual liberties. Article 32 serves as a safeguard against arbitrary actions of the government, enabling the judiciary to act as a guardian to of the Constitution and arbiter of justice. Let's see what is Article 32. Article 32 gives you the right to move to the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. The Supreme Court shall have power to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Now let's see writs and writ petition. A writ can be analog to a written directive issued by a higher court to a court of lower jurisdiction or to an individual in cases where there has been a violation of a citizen's fundamental right. In accordance with Article 32 of the Indian Constitution, the Indian Supreme Court possesses the authority to issue such writs. A writ petition refers to a formal written application or document submitted to a court, typically a higher court seeking legal remedies or relief for the violation of fundamental rights or a legal right. Now let's see five kinds of writs given under the Constitution of India. Let's start with the first one, habeas corpus. Habeas corpus, derived from Latin meaning "you shall have the body," is a legal recourse that ensures the protection of individual liberty by enabling a person who is unlawfully detained or imprisoned to seek immediate release. This legal remedy, deeply rooted in the principles of due process and fundamental rights, has been upheld and reinforced through various significant case laws. One notable case that exemplifies the significance of habeas corpus is the landmark judgment of Maneka Gandhi versus Union of India. In this case, the Supreme Court of India expanded the scope of personal liberty and emphasized that any law depriving a person of their liberty must adhere to the principles of fairness, reasonableness, and procedural safeguards. Mandamus. Mandamus, a writ derived from Latin meaning "we command," is a powerful legal remedy employed to compel a public authority or official to perform their lawful duties and fulfill specific obligations. It serves as a judicial tool to ensure that public officials act within the boundaries of the law, exercise their powers judicially, and do not abuse their authority. A significant case that resonates with the significance of mandamus is the State of Bihar versus Bal Mukund Shah. In this case, the Supreme Court of India reiterated that mandamus can be invoked when a government servant is wrongfully denied promotion despite meeting the necessary eligibility criteria. The court held that if the authorities failed to rectify the injustice and grant the promotion deserved, the writ of mandamus can be issued to compel them to act in accordance with the law. Prohibition. Prohibition refers to a writ issued by a higher court to a lower court or tribunal, restraining them from exceeding their jurisdiction or acting beyond their authority. It acts as a safeguard against potential miscarriage of justice or unlawful exercise of power by lower courts. Prohibition ensures that lower courts operate within their prescribed limits and do not transgress the boundaries of their authority. Certiorari. Certiorari, derived from Latin meaning to be certified, is a powerful writ employed by higher courts to review the decisions of lower courts or tribunals. It serves as a mechanism to ensure that the lower court's judgment is in accordance with the law and to correct any errors of law or jurisdiction. Certiorari acts as a safeguard against judicial overreach or miscarriage of justice, reinforcing the principle of fairness, equity, and the rule of law. Quo warranto. The writ of quo warranto, a legal term derived from Latin meaning by what authority, is a powerful legal remedy used to inquire into the legitimacy or validity of a person holding a public office, position, or franchise. It challenges the authority or qualifications of the individual and seeks to prevent the unlawful occupancy of public positions. Quo warranto acts as a mechanism to ensure that public offices are held by those who are duly qualified and have the legal authority to occupy them.